Member for Long Island.
Mr. Deputy, Mr. Deputy, I rise on behalf of the wonderful people of Long Island, whom I'm grateful to have the privilege of serving in this place. Mr. Deputy, I rise with an abundance of gratitude for their love and their support, and for them reposing their confidence in me to represent them in this place. Every day I get all of your calls and your messages, all of your love, your prayers, and your support that strengthen me and boost my spirit, and more often than not, makes my day. I am grateful for every call, every text, every message, every email. And so I thank all of you from the bottom of my heart. Mr. Deputy, before I begin, I want to extend condolences to Mr. Craig Pratt on the passing of his girlfriend, Miss Arabella Adderley, known as Bella, the mother of his 2 children. And I further extend condolences to the family of Bella, who's out of Deadman's Key, Long Island. Mr. Deputy, Craig is an avid PLP general, and I've lined up in political warfare against him on 2 separate occasions now as political opponents. He's a soldier for the other side, and we've only seen each other across battle lines. It's quite formidable, but Mr. Deputy, today, we line up side by side as human beings, as I pay my respects to them as they grieve such a loss. So may her soul rest in peace, and my prayers are extended to Craig and his family. Mr. Deputy, in Long Island, we have a situation with BTC. The landlines are constantly down. The cell phone lines are often not working. The internet service is poor. So BTC, the service leaves much to be desired, and we are hopeful that they would step it up and move to correct these deficiencies and inefficiencies in their system. A bunch of dead zones, dropped calls, dropped everything, with constant bills for no service. Mr. Deputy, every time we look around, we hear about the carnage on our streets. Every time we look around, we hear about the carnage on our streets. We have seen mafia-style killings and hits while citizens are driving in traffic, or while folks are on their porch with their families, charging their phones, etc. We have seen many Bahamians, speaking to the press and otherwise, telling you that they are afraid to sit on their front porches, to enjoy an evening with their significant other, or just to relax. Mr. Deputy. Mr. Deputy, we're here to debate amendments to the Bail Act. But there are many questions that arise from not only this bill itself, but various circumstances related thereto. But Mr. Deputy, Bahamians are being murdered virtually every day at an unprecedented rate. These proposed amendments today, to me, from our observation, is merely window dressing. And frankly, I think this should go to committee and remain there for further review, amendments, or otherwise. This is a vacuous attempt of this administration that has failed to curtail violent crime and has presided over one of the bloodiest months in the history of the Bahamas. 2024 started off with the persistent and constant bang-bangs of high-powered guns, and with a nation, particularly Nasuvians, living in fear, running for cover at the slightest thing that sounds similar to a gun, whether it's firecrackers, a defective car muffler, and with governments elsewhere expressing concern. Mr. Deputy, let's not forget that more than 70% of our tourist yield. Mr. Deputy, this bail amendment is a desperate attempt at curry favoring with a fed-up, fearful public who is witnessing the carnage on our streets and questioning what happened to all the far-reaching, big-talking promises of a government who, in their blueprint for change, said it's a new day, and that they had solutions to violent crime. They told the public, pick me, and the electorate certainly did so, in hopes of a new day, as promised. Sadly, we've only seen one bloody day after another bloody day. We've seen young men and women stretch out on the streets, or in bushes, or between car doors, dying or already dead. That is what we have seen, Mr. Deputy. Mr. Deputy, this amendment today is an amendment about public opinion. And frankly, it is an amendment that could warrant constitutional challenges. The Constitution guarantees all a presumption that one is innocent until proven guilty. Sir Brian Marie, former Chief Justice, said, and I quote, "We have to understand under the Constitution there's a presumption of innocence, and the Court of Appeal has laid down very clearly what these principles are that must be applied. It's not a question of the judge wanting to grant bail or not wanting to grant bail. That isn't the issue. It is a question of applying the law with regards to these applications. And when that is done, the judge either grants bail or does not grant bail." So, Mr. Deputy, the presumption of innocence is paramount. It is one's liberty at stake that requires us to be cautious and to be circumspect. Put simply, Mr. Deputy, bail is described as the conditional release of an accused person with the promise that they will appear to court when required. And so we know that property or money is used, given as a surety, someone stands in, and such a person is then released from custody to return at an appointed time. You know, having said that, Mr. Deputy, the police themselves can give bail. We've all heard of police bail. Someone can get locked up right now for, let's say, a minor offense and obtain police bail right at the police station. Mr. Deputy, will the changes to the Bail Act make us safer? I highly doubt it. This is certainly not the panacea to crime in the Bahamas, nor are these amendments representative of any real, tangible solution in the fight against violent crime or the poor socialization of our young men and women. To use the words of the Bahamas Bar President, Khalil Parker, and he said this week in The Guardian, anyone who believes that the amendments will make them safer have been hoodwinked. We must address the root causes of crime, Mr. Deputy, the systemic issues that lend to violent crime. Do I support a person being on the streets who has been charged with committing 2, 3, 4, 5 murders? Definitely not. It's certainly the exception to the rule, and frankly, Mr. Deputy, right-thinking people would wonder how such a person would have been given multiple grants of bail for the same violent offense. So that is an issue that could be looked at separately. That is an administrative issue. Mr. Deputy, To demonstrate that this bill is mere political fluff, I will take you to the first section of the proposed amendment. And that is, and I'm going to illustrate the point at section 9A, which provides, 1, where a person is granted bail in accordance with this act, he shall be required to enter into a recognizance of bail, which shall contain the conditions to which the grant of bail is subject. 2, the recognizance of bail should be in the form in the 3rd schedule. And 3, the breach of the conditions contained in the recognizance of bail shall result in a revocation of bail. I want to stop there. Firstly, Mr. Deputy, the act already provides, the existing act already provides that where the court makes an order for a person to be released on bail for serious offenses, for example, the court has to give reasons why it released the person on bail in writing. That's already there. Secondly, Mr. Deputy, whenever any person is being considered for release on bail, the law already requires that a court shall, that all sureties must sign a statutory declaration. That's already in the law. And that statutory declaration, 1, acknowledges that they would owe the Crown the sum of money that is assessed for bail. Number 2, it lists the property that these people will be putting up for bail. And thirdly, it also acknowledges the authority of the Crown to levy against their property if the defendant does not live up to the conditions of their bail. That's currently existent in law. Thirdly, Mr. Deputy, the new section 9A now conflicts with the previous section 9 of the Act. Section 9 of the previous Act provides that when a person applies for bail, the court has to consider 10 very serious factors before it grants bail to that person, and those factors are as follows. A, whether there are substantial grounds for believing that the defendant, if released on bail, would, A, 1, fail to surrender to custody or appear at his trial, 2, commit an offense while on bail, or 3, interfere with witnesses or otherwise obstruct the course of justice, whether in relation to himself or any other person. B, whether the defendant, it's 9B now, whether the defendant should be kept in custody, or that currently is existent, whether the defendant should be kept in custody for his own protection, or where he is a child or a young person. You know, Mr. Deputy, there's a case, a Court of Appeal case, D'Antoine Grant versus the DPP, 2022 case, where their lordships, Sir Michael Bonnet, Mr. Justice Isaacs, and Madam Justice Crane Scott, said, once there's a basis that an accused person may be attacked on bail, the court is obligated to deny bail to the applicant. The attack on the applicant, on the appellant, days earlier is a basis to deny bail. However, a caveat can be applied if the applicant can demonstrate to the court that notwithstanding a finding that his life may be in jeopardy if released on bail, he is able to minimize the risk. The appellant submits to this court that he is willing to relocate to another island. Unfortunately, that submission was not made in the court below, and the judge cannot be faulted for not applying her mind to the efficacy of such a condition in the circumstances. Essentially, with this, the Court of Appeal affirmed the ruling of the lower court that denied bail to an applicant for his own safety. Going further, this is currently in statute C, 9C, whether he is in custody in pursuance of the sentence of the court or any authority acting under the Defense Act, whether there's sufficient evidence or information for the purpose of taking decisions required by this part or otherwise by this act. E, whether having been released on bail or in connection with the proceedings of an offense, he is arrested pursuant to section 12. F, having been released on bail previously, he's charged subsequently either with an offense similar to that in respect of which he was released, or with an offense which is punishable by a term of imprisonment exceeding 1 year. G, the nature and seriousness of the offense and the nature and strength of the evidence against the defendant. And H, In the case of violence allegedly committed upon another by the defendant, the court's paramount consideration is the need to protect the alleged victim. Mr. Deputy, this is what the law says, as is. As is. So after considering these factors, the court can grant bail right now. But under Section 9, the law provides that no condition can be attached unless it is considered necessary.
Honorable members,
My time, my time,
all the time.
my time.
The chair, oh, yeah, go ahead.
Mr. Deputy. So, Mr. Deputy, the current Section 9 already provides for these conditions and these stipulations. So this new amendment is of no moment. The problem now, Mr. Deputy, is that the new amendment imposes two conditions that directly contradict the provisions of Section 9. In short, the law already says that conditions may only be required for certain purposes. And the amendment now says no matter what, two conditions are to be imposed. So judges must be looking at that with alarm, with great alarm. Frankly, Mr. Deputy, requiring an accused person to sign another form called a recognizance is only more paperwork. It's only more paperwork. On top of that, the surety doesn't appear or doesn't even need to sign this recognizance. So you already have a form that is signed as is for persons on bail. And that's a statutory declaration. This recognizance is just repetition of what already exists. So, Mr. Deputy, this bill is defective. You take a look, Mr. Deputy, look at the objects and reasons. It says, I'm looking at C, Section 12(2), where a surety of an accused person released on bail notifies a police officer in writing that he wishes to be relieved of his obligations as surety. The person can be arrested and shall be brought before a magistrate and may be remanded or committed to custody or released on bail subject to the same or different conditions on bail. You see, what that does, that seems a bit whimsical. There's a danger in that. People get mad, people break up, people could then play with someone's liberty. You decide you're going to withdraw your support because of some issue you may have. How do we prevent this from being abused by persons who might be operating in spite? Mr. Deputy, I go further. D, and the objects. It says in Section 12(8) to provide for the application by the prosecution to the Supreme Court for the revocation of bail where a person is convicted of the offense of breaching the conditions of bail. Well, Mr. Deputy, there's a case here. Bartholomew Pinder and the Queen, where it says here, and the prosecution don't have to apply to the court for the revocation of bail. Bartholomew Pinder and the Queen. It's a Court of Appeal case decided in 2021. Their lordships, Sir Michael Barnett, Mr. Justice Jones, and Mr. Justice Evans presided in this case. And they said there's ample jurisdiction in a judge of the Supreme Court to revoke bail granted by the court. The fact that Section 12 was recited in the summons is inconsequential. If the issue of jurisdiction has been raised by the appellant before the justice, he could have readily granted leave to the Crown to amend the summons to refer the courts to the court's inherent jurisdiction. In other words, Mr. Deputy, the courts already have an inherent jurisdiction to grant and revoke bail. So here again, Section 12(a), this amendment, is of no moment. And then you have here in the object in Section 12(b) to remove the discretion of the magistrate to impose a fine on conviction for a breach of bail conditions. That should have remained. The magistrate should still be able to impose a fine. In fact, this fetters a judge's discretion generally these proposed amendments. Mr. Deputy, at common law, and under the current state of the law, a judge already has the jurisdiction and the discretion to grant, to refuse to grant, to continue bail, or to discontinue bail. A judicial discretion is exercised judicially. Common law undergirds that. This discretion can never and ought never be taken from a judge, whether he be a Court of Appeal judge, a Supreme Court judge, a magistrate, or a lay magistrate. And so we must be careful when we are discussing legislation that impacts the discretion of a judge. If one purports to take away the discretion or fetter that discretion, we are talking about matters that potentially breach the doctrine of the separation of powers. This could be perceived as a direct interference with the exercise of judicial discretion outside of any context, factual or otherwise. Some people may have good reason not to turn up at court even, Mr. Deputy. And so we have to be careful not to put blanket conditions out there either. Mr. Deputy, we must not create a situation where Parliament seeks to put a judge in a straitjacket with respect to their exercise of judicial discretion, or to breach the separation of powers doctrine, or simply to overreach. There's a case out of Mauritius, Korati, where the government of Mauritius, a Privy Council case, the government of Mauritius sought to, they amended the Constitution to not allow bail at all. And they purported to remove this right to bail. The case is the State versus Korati, Mauritius, 2006 case before the Judicial Committee of the Privy Council. And this case, of course, the Privy Council rejected the same because this was an overstep. The Privy Council held that these enactments were void, that they could not be upheld in the interest of lawfully protecting a subject or an accused person. Mr. Deputy, it underscores, we must underscore, I want to say here, I want to express the importance of removing politics from the arena in which judicial discretion is exercised and the sanctity of the judicial process. Bail provisions, or these bail provisions, appear to be a usurping of a core judicial function and appear to be overstepping and breaching the separation of powers doctrine. None of this, I believe, actually has anything to do with the occurrences of violent crime. Since this debate began, from the Prime Minister or whomever, I think it was laid the initial bill, a man was shot on Village Road and Pargate Road. And assailants did so with CCTV cameras pointing right at the intersection. So clearly, the availability or unavailability of bail in that instance was irrelevant to those persons who were hell-bent on violent crime and who were focused on killing the victim. And so we ought to be focused, Mr. Deputy, on addressing the real problems that exist, that cause violent crime. Just this week, we have seen instances where judges have revoked bail. So when we talk about the DPP and those being able to apply for revocation of bail, again, that's an inherent jurisdiction of a judge. Mr. Deputy, this bill appears to be an admission by the executive that they're not doing what they're supposed to do. Where's the scientific forensic lab of the Bahamas? Why is the government late with paying the American forensic lab? You know, the government has a history, repeated governments have a history of not paying on time, and that contributes to the unavailability of evidence needed for court. We should have had a forensic lab in the Bahamas many, many years ago. And we've had people who went away and trained to be forensic scientists. Quinn McCartney and the gentleman who owns Kelso Medical, he was a policeman, retired and opened Kelso Medical. These are some of the persons who are forensic scientists right here in the Bahamas. Right here in the Bahamas. And so, Mr. Deputy, with respect to 8A3, I know that they have extended it now. They're proposing in the amendment to extend the time to 7 days from 2 days, where one could apply or could appeal a decision with respect to bail. Why not simply populate the DPP office with lawyers who can effectively manage the backlog of cases? Why not maintain appropriate funding and staffing levels, addressing deficiencies in the system, rather than attacking the civil liberties of law-abiding citizens? No doubt, Mr. Deputy, as I've said before, this will be subject to a constitutional challenge. I refer to an article, a Tribune article in 2016, where Fred Smith King's counsel, he was speaking on some amendments that were made then to the Bail Act. He said, this is completely unconstitutional. When a person violates your bail or their bail, you can cancel it, simply cancel it, and place that person in custody until trial. That is the essence of bail, and that's what could be done. It is shocking, I'm still quoting from him, it is shocking that parliamentarians do not understand this. The person is presumed innocent until convicted. And so how can you convict someone and charge them with an offense which could possibly carry a bigger penalty than the offense they were originally charged with? It is perverse. And this is Fred Smith, QC, in 2016. And so, Mr. Deputy, what is being done is not addressing the backlog of cases in the court system. Why should an innocent person sit on remand for 3, 4, 5 years without the possibility of bail? Again, there must be greater financial support, greater staffing and other resources made available to judges as well as to the prosecutorial department. Would it not be better to expedite a person's ability to have their trial heard in a timely manner, and to do so by providing the resources necessary for that to happen? Right now, Mr. Deputy, for murder cases, pathology reports are backed up. This month, the Attorney General himself said that there were 150 matters in the courts awaiting pathology reports. To go to trial in a murder case, one must have a pathology report. Unfortunately, in the Bahamas, we only have 2 pathologists who are handling all the deaths in the country, as well as hundreds of murder cases. So if the government is really serious about combating violent crime, why not hire 5 to 10 additional pathologists? Recruit them, bring them in if you need to. Do whatever is necessary, because we know that a murder case cannot advance without a pathologist report, and they are backed up. When you look at the numbers today of murders, the murder rate, it is almost hard to believe that between 1973 and 2010, there were only, I wouldn't say only, there were 1,817 homicides in total in the Bahamas from 1973 to 2010. 1,817 homicides. So one is curious to know what is the number between 2010 and 2024 today. Fox Hill can accommodate less than 1,400 inmates, and maximum security can accommodate less than 450. So with the government proposing to take what appears to be a blanket approach to people on bail, where will they house prospective bail offenders? I'm sure if there's 1,400 to 1,600 people in Fox Hill, there got to be about an easy 6,000 to 10,000 people possibly on bail. And that may be a bit much, I don't know the exact number, but the point is, where do you house possible offenders when the prison is already bursting at the seams? Is the government building a bigger prison and hiring more corrections officers? Are we going to do that? Because right now, we got about 435 persons in prison to every 100,000 Bahamian. Otherwise, if we're not building a new prison, hiring new corrections officers, this bill is like putting the cart before the horse. Mr. Deputy, I recommend, and there's a few recommendations I'd like to make. I recommend that the government renews and implements some of the strategies set out in the Needham's Point Declaration, as was spoken to by His Lordship, my former lecturer, the Honorable Chief Justice, Sir Ian Winder, in his address at the opening of the legal year this very month. And in that, His Lordship said, recommendations 29 to 39 related to judicial interventions, and these are some things he's looking to put in place. 29, that a new category of judicial officer should be created, or existing judicial officers will be deployed to deal specifically with pretrial issues in criminal matters. 32, that a sentencing guidelines commission be established in each jurisdiction. 34, this is from the Needham Declaration, that the court should adopt a focused and integrated approach to eliminate criminal case backlogs by using tools and measures such as a robust case management coupled with plea bargaining discussions. So Ian went on and said, if we can provide for binding evidentiary hearings to take place before the trial, this would obviate the need. Mr. Deputy, I need a few more minutes to wrap up. Thank you, sir. So Ian said, if we provide for binding evidentiary hearings to take place pre-trial, this would obviate the need for a jury to be empaneled, especially in circumstances where the determination of the issue may decide the entire action, that is pre-trial and evidentiary hearing. He said a draft amendment to the criminal case management rules to encourage and provide for pre-trial evidentiary hearings in the Supreme Court has been favorably considered by judges in the criminal division. So Ian went on to talk about establishing or making recommendations with respect to sentencing ranges. And last week in the House, in this very House, I spoke about categorizing murders, first-degree murder, second-degree murder, and so on. Mr. Deputy, I want to conclude with a few other recommendations as we move, or as we put strategies in place to fight crime. And I take some of these from a letter I saw, an opinion from Dame Anita Allen, former president of the Court of Appeal of the Bahamas. And I think the government should seriously consider some of these recommendations. One, to increase the number of public defenders and possibly even the panel of jurors. Two, to improve the process of summoning. Three, to improve the process of selecting jurors. Four, to provide for the protection of jurors. Six, increase the capacity of the police forensic lab. Let's bring a lab to the Bahamas. Let's put a lab in place so we don't have to send out samples to the United States and have to wait. To weed out the backlog in the system. And of course, to ensure stricter compliance with the law and rules of procedure by all actors in the justice system. And that includes both defense and prosecution, because, you know, we all know, those of us who've practiced in the private bar, issues concerning disclosure and the lack of disclosure and how that could impede a trial. And lastly, Mr. Deputy, another recommendation is that we consider possibly having trials by panel, and I'm talking about at the Supreme Court level, of judges, maybe 3 judges. That is a consideration, particularly in cases like murder and manslaughter. Those are real and tangible reforms to address the issues we have in the country as it relates to the fight against crime. And that is outside of the police having saturation patrols and so on and so forth. Mr. Deputy, I thank you.